religious values shall not be taken to discriminate against a person for the purposes of that. And there were two conditions. One, it gives more favourable treatment on religious grounds to an employee or a prospective employee over the person where it's reasonable to do so in order to maintain the religious ethos of the institution. That's the important point. And two, it takes action where it's necessary, where it needs to be necessary to prevent an employee or a prospective employee from undermining the religious ethos of the institution. So whatever one's views about Section 37 of this Act, and I know the teaching unions have a very fundamental view about it, which I understand, what it said was this, that a religious, educational or medical institution can take into consideration effectively things which would ensure that the religious ethos of the institution be upheld, and secondly, it can prevent employees from undermining the religious ethos of the institution. Now, what was important about this bill was, under Article 26 of the Constitution, President Mary Robinson sent this article, sent this section for consideration by the Supreme Court. And the Supreme Court gave a very significant ruling in saying that, yes, this was constitutional, but it put parameters on the constitutionality of Section 37. The Chief Justice said, no serious criticism can, however, be advanced against the section, which entitles an institution to prefer a particular candidate on the grounds of his or her religion, if in fact being of that religion is an occupational qualification for the post in question. The attack has been directed against the subsection which entitles an institution to give more favourable treatment on religious grounds to an employee or a prospective employee, where it's reasonable to do so in order to maintain the religious ethos of the institution, or to take action which is reasonably necessary to prevent an employee or a prospective employee from undermining the religious institution. The Supreme Court found that it was constitutionally permissible to make directions or discriminations on the grounds of religious professional belief or status, insofar as it may be necessary to give life and reality to the guarantee of the free profession and the practice of religious contained in the Constitution. So what the Supreme Court said is this: religious groups are recognised, denominations are recognised. Nothing can be forwarded in law which prevents people coming together, which prevents people from professing their faith, which prevents people from ensuring that that faith is upheld. It was the ruling of the Supreme Court on this issue, which has direct relationships to the question of a freedom of conscience clause, related directly to the idea of the institution of the religious group itself. It didn't give a direction. It didn't allow the state to positively discriminate one way or the other. What it simply said was this: where it came to the religious groups, they have fundamental rights, and nothing should be advanced which will undermine their rights as religious groups in the context of the institution. It does not give a right to registrars. And if this comes before the Supreme Court again, which it may, I believe the Supreme Court will rule forcefully again that officers of the state cannot allow themselves to opt in or opt out of this legislation. So I think there's absolute current Supreme Court ruling on this, which says to registrars that if they are officers of the state, they must enforce this. Now, the point is made in a traditional marriage, of course, the priest or the rector or whoever performs a dual function. He performs the civil marriage. He also performs the religious marriage. You couldn't have this under the civil partnership legislation. You couldn't have this because that recognises the role of the religious in terms of the marriages. So the point I'm making in all of this is this: I do not see any justification to the argument that has been put out there by some groups that we can allow a freedom of conscience clause in this legislation. I don't think it holds up to scrutiny. I think it is abhorrent to the Supreme Court ruling in the case of the Employment Equality Act, and I would make the point that that section, the narrow section of Section 37, was looked at in the context of the President sending the Act for consideration by the Supreme Court. So to those people who are looking for a freedom of conscience clause in this, I don't think it holds any constitutional water. I don't think it will be supported were the matter to come before the Supreme Court again. And I would ask people, in the spirit that this legislation has come about, to recognise that this is a good day for the country, a good day for those people who are looking for recognition, looking for their rights to be upheld by the state, and for people to give this a fair wind when it is ultimately passed by both houses of the Oireachtas.